our next two speakers. We have Raluca Deaconu, who is the Head of Unit for Life Sciences and Impact Legal Services, and Gizem Tasher from the Legal Counsel, Senior Legal Counsel. They are going to talk about the typical legal obligations for an EIF deal. So please welcome them.
Hello, everyone, and thanks to those who have already joined us. Gizem and I have been tasked to give a legal presentation to an audience of non-lawyers and to do so right before lunch. What can be easier, right? But do not worry, we will do our best to make it as useful and practical for you. And what we aim is that at the end of the next 30 minutes or so, you will be better equipped if you are to interact with EIF after that, to anticipate, understand, and hopefully accommodate our legal requirements. We are planning to split the presentation in two parts. I will start by giving you an overview of the legal framework that we operate under at EIF, and then Gizem will go through the details of the main terms that we usually negotiate with the fund managers we are financing. You heard from Iruna in the previous session that an important tip in fundraising is to know your investors. So that's pretty much the objective that I have in mind with this part of the presentation, to help you better understand what prompts and shapes the positions that we take during the legal negotiation at EIF. And to do so, I will start with this overall presentation of EIF. Now, you have seen so many numbers since the morning about what we do. So this is my attempt at dazzling you with some really big figures also. But frankly, you don't need to spend too much time looking at the slides. I'm going to try to convey all the relevant information orally. And the takeaway is that for the last almost 3 decades, we're actually about to celebrate our 30th anniversary in 2024. We have been active in the private equity and venture capital markets, and we have tried our best to build and grow this ecosystem. And we have become ourselves a very important player therein. The figures that you see behind me speak for themselves. We have a pretty impressive portfolio under management, more than 1,000 active funds currently. And with the decades and every coming year, we have been asked to increase our activity in this space. Basically, every crisis that the EU has gone through has seen an increase in volumes and speed of investment for EIF, up to the point where last year alone we invested in no less than 120 funds, some 4 billion euros in total. So what I want to say with all this is that we are an institutional investor that knows the market very well. And especially in the legal team, we take a lot of pride in our intimate knowledge of the market, and also the role that EIF is playing as a guarantor of quality, if you wish, for the funds that it selects. So we know that other LPs are looking at us to do the heavy lifting during due diligence phase and legal negotiations. And we indeed turn every word when we review your fund documentation and make sure that it is up to that market standard that we know so well. And how does this translate for the legal service? At EIF, we have one of the biggest in-house legal teams that is dedicated to fund investment. We are currently 20 lawyers doing just funds from pretty much all over Europe. And in order to deliver the big volumes that I was mentioning, we partner with many of the law firms active in this space. Every 3-4 years, we launch a call for applications and we create a panel of law firms. And at the moment, we have some 18 different legal firms throughout Europe that are regularly supporting EIF in negotiations. So it's really a huge extended team that is spending a lot of time in ensuring that all the requirements that EIF is bound by are translated into contractual terms in the investments that we make. And this is another thing that I want you to keep in mind when you try to figure out for yourselves what is EIF and what type of an investor is it. We are a fund of funds, you've heard that already. So while we will be investing own resources in pretty much any fund that we back, that's going to be really a very small portion. The vast majority of the money comes from our mandators. And to recap on what you were told already earlier, we fundraise primarily from our main shareholders, so from the European Commission and the EIB, but also from the member states and their respective national promotional institutions. And more recently, we also fundraise from private investors. And all of these have their own requirements, expectations, and especially for the first three categories, their policy objectives that they want to achieve with the financing that they provide. So we need to make sure to trickle down these requirements in the documentation that we end up signing with the intermediaries, so with the fund managers. And that's going to inform to a very large extent the positions that we are taking in the negotiations. And it's also going to be hard requirements on our side. So if it comes as a string attached to the funding, we will not have much leeway in making concessions, even though the fund managers might want or hope that we do. Also important to know that we are operating exclusively under an intermediate model. So we select the fund managers and we spend a lot of time negotiating the terms of their funds, but thereafter we are basically in the passenger seat. So it's really for the managers to build a portfolio, make the investment and divestment decisions, and we do not have contact directly with the portfolio companies. So now more technical elements. As you could tell from the previous slides, mandates are an important element that dictate the terms and conditions that will be attached to the EIF funding. But it is not the only thing. We have developed, ever since we were created, a very thorough set of internal guidelines and policies that we need to follow. And we have a comprehensive internal approval process that is also going to impact the final outcome of the terms and conditions we can offer. So first, when it comes to the guidelines that I am mentioning, we have the so-called equity investment guidelines that regulate important parameters of the funds that we fund, and this apply across the portfolio, so irrespective of the mandate that we use. It covers things like the geographies, the focus, and some important investor protection elements. And we also have the EIF Good Market Practice, that is a compendium of the terms and conditions we see as the golden standard, if we wish, that we seek to incorporate in the documentation we negotiate. And this is a standard that we want to promote throughout the industry in Europe. In addition, I was mentioning that we have a comprehensive internal approval process. So while you will be interacting first with the front office colleagues and later on, if you're successful with your application with us in legal, know that we are acting on behalf of the EIF as a whole. So behind the scenes, we get a lot of input from all relevant services, notably from compliance and risk that might come up with certain concerns and might ask for certain parameters of the underlying funds to be strengthened before we can proceed to an investment. So all of this will be included in the approval documentation that go to our governing bodies, and these governing bodies in turn might want us to include certain elements in the documentation. So if we have any CPs raised, for instance, by the board, you can bet that they will find their way into the legal documentation we are negotiating with you. So all of these elements are going to be translated into requirements that you will see us raise during the negotiations, and will be transposed in one way or another in your LPA, in our side letter, and the rest of the fund documents. So, just to give you a better understanding of the level of complexity that I'm referring to when I talk about this internal document, on the screen you have a snapshot of the good market practices of EIF. And I don't want to go into the detail time doesn't allow to, but I wanted you to see just how many different topics are covered, and you will see that there are things ranging from how the fund should be managed to conflict of interest in economic terms and alignment of interest. So really, we are looking into details on pretty much any relevant parameter, and we have to ensure always compliance with these internal standards that we have in place. Last but not least, before I hand over to Gizem, I wanted to take a moment to look at the fund documentation. Most time is spent during the negotiations on the fund's main document, which is the LPA. It might have different names in the various EU jurisdictions, but it is the core document regulating the fund and its interactions with the LPs. But please note that once we have an agreement on the LPA, the journey to signature is not over, far from it. At EIF, we have a very well-developed side letter, and that keeps growing with the years. I see my colleagues smiling complicitly. It's more and more challenging these days, I'm not going to hide that from you, to negotiate the side letter. And I have to warn you, if you haven't had the pleasure of interacting with EIF yet, that this document is unlike most side letters that other LPs are going to come up with. So it's a very long document, and it contains many of the requirements that I was referring to earlier. And what is important for you to remember after today's presentation is that we have standardized this document over the years, and we have included, the wording that we found most clear and closest to the objectives that we are trying to achieve and that we are bound to achieve. But in reality, this is the document where we have the least margin of negotiation. So while we'll be always very happy to explain to you what we are pursuing with the various clauses and to clarify the wording here and there, know from the outset that it's going to be a bit of a futile exercise if you're going to imagine that you can change it drastically. Similarly, on the subscription agreement, you and your external counsel will most likely aim to have a document that is pretty much the same for all investors when it comes to the actual subscription agreement. And we are trying to accommodate that, but again, we are a supranational financial institutions that has a series of specificities that are unfortunately not always fitting with the standard terms and conditions of subscription agreements that we see in the market these days. So certain reps and warranties, certain US considerations, we will need to adjust in order to be able to proceed to signature. So keep it in mind again that we will not be able to most likely turn it around in 2 days and just put our signature at the bottom. We will probably be negotiating that as well. Last but not least, we will be demanding for each and every transaction that we are provided with legal and tax opinions by your external counsel. And here also we have a comprehensive policy in EIF that regulates the terms and conditions that should be covered, especially the items that these opinions should cover. And I want to take the opportunity linked to the opinions, but not only, to share from our experience over the years how important it can be that you make the right choice when you select the law firm that is going to help you draft your documentation. Not just because the legal opinions and the other documents are going to be very technical and we are going to scrutinize closely that they meet our standard, but in general, if I can give you some advice on this, there are many law firms out there, and we work with many of them, as I was saying earlier, that have funds experience, that know the industry, that have come across institutional investors already. Many of them will have come across us specifically, which is a big plus. So it can help save a lot of time and hence legal cost, and also ultimately unnecessary frustration. If you select the right advisors on the legal side that can meet us halfway and have a pragmatic, quick and constructive discussion on the legal terms. That was it on my side. Unless you have any burning questions, I'll hand over to Gizem and we speak at the end. Thanks.
Thanks, Raluca. So in this session, I will try to talk about a few of the selected terms that we discuss, mainly from the LPA, because the side letter is another story, and the LPA is more the market standard terms that we would go into details and negotiate for hours and hours with your counsels. So at this point, your fund lawyers will have drafted all the legal documentation and will have provided us a market standard LPA. And from then on, we will take that forward and we will provide our comments. If we're using lawyers with their assistance, we could also do it internally in-house because we're 20 lawyers, as Raluca mentioned. So the main characteristics of our investments in private equity, VC, private debt, infrastructure funds is that it's a long-term commitment. So minimum 10 years plus with extensions. Those extensions can happen with LP, investor consents. So all these are set forth in the LPAs, the minimum term and the possible extensions, but also as Gislan mentioned earlier, funds may have been extended to 20 years of term too. So what we're looking is to remain long-term in these funds, except for perhaps occasional secondary sales that might have happened. We've done those too. We're also active in the buying and selling of LP stakes in funds. The principle is that we enter into closed-ended funds. So we don't invest in open-ended funds. The funds must have a defined subscription period. After the subscription period, the fund closes, so no more investors allowed in, and then it's locked. So it's not easy to sell your shares in that fund as well without the consent of the GP, and in some cases even of the other LPs. And then we rely on the manager's discretion on making the investment decisions. So you've seen in the previous presentations that we invest in a team, and that team will have the discretion to select all the investments. And that's why we need to very carefully define the investment strategy of the fund in the LPA. So there will be a dedicated section in the LPA on the fund's investment strategy. It will set out the types of companies the fund has to invest in, how much of the total commitments, X percentage of the total commitments needs to go into these types of companies, this geography, etc., the stage as well. And then we will also set out all the additional commercial terms in the investment strategy, like borrowing limits, diversification limits, meaning how much exposure the fund can have in a single investment, because we need to manage the risk in that sense. So once we spell out all those terms in the investment strategy, then we rely on your call to select the investments. And where we're active as an LP is the advisory committee of each fund. So we require a seat to be given to the EIF at the advisory committee. It may be also called the advisory board, the LPAC, investor board, so you see different names in the industry. But there we're very active, so a person from our business team is allocated to that fund, and they go and attend the advisory board meetings, either physically or by phone, email, etc. So these happen occasionally during the term, and they reviewed the performance and the budget of the fund. They're very active. And the advisory committee has a consultative role, so meaning that they have the duty of clearing any conflicts of interest. For instance, if the fund manager wants to do any related party transactions or so-called crossovers, which is sort of buying and selling with related funds within the same group, those all need to be cleared by the advisory committee. And this is all spelled out in the LPA in detail. The advisory committee can also provide approval for extension of the investment period. It can have the discretion to, not the discretion, but if the key persons are going to change, then this will also require the permission of the advisory board. And at the advisory board, of course, we're not alone there, so we need to have other LPs representatives along our side, because we cannot control the advisory board. So we just have one vote there, but we need also reputable LPs representatives along our side. And also the other reason that we cannot take investment decisions is because of the fact that we need to have a limited liability in the funds. So each LP's commitment is limited. Sorry, liability is limited to their commitment. So if we were to be taking investment decisions all of a sudden, then that infringes our liability limitations. So the investment committee is composed of the GP's team or the persons selected by it. And then moving on to certain protection rights. So here I just picked a few because there is no time, but important stuff for us. So first is key persons, also called key men in certain cases. So now it's more called key persons in agreements. So the time dedication criteria of the key team has to be defined. So for us, the standard is substantially all the business time of the key team. So the key team shouldn't be engaged in any other ventures, etc. in principle, as long as they're not creating synergies for the fund, which you discuss with our investment team, and then we can permit those. But the idea is for the key team to be fully dedicated to the fund during the whole term of the fund. Sometimes we discuss, during investment period, can we do that? After the investment period, maybe we spend less time. We all discuss these options. But the idea is to be fully dedicated. And then a key person event is also spelled out in the LPA. What a key person event is when a key person leaves. But also we have criteria for these. Sometime in some funds, in bigger teams, it's not triggered with the departure of one key person. It could be triggered with the departure of two key persons, etc. But we all have the mechanisms and the principles of the key person dedication. And if they leave, what will happen? So the idea is, first, before somebody leaves, the manager has to come to us to the advisory committee for our consultation, and then propose a cure mechanism, who to replace them with, and their credentials, their background, and that's discussed with the advisory committee. And if the advisory committee is happy with the new person, then everything is fine. However, if a key person leaves and the situation is uncured, this will then lead to certain removal rights that the LPs may have, which I will explain in the next slide. And then also my colleagues before mentioned exclusivity. Not only exclusivity of the key persons, but also exclusivity of the GP is important for us. So if it's a new manager, they shouldn't ideally be setting up other funds. Or if it's an established manager, then for the investment strategy, this fund should be the sole fund up and running with that investment strategy, and with a different investment strategy, there could be another fund, perhaps, but to be discussed. And then if there's going to be a successor fund after our fund, then there shouldn't be any overlap between the investment periods of those both funds. So these are all spelled out in the LPA in a very detailed manner. And about change of control, so the concept I'm sure everybody is familiar with. It's very important in shareholders' agreements. We need to ensure that the ownership remains the same in the GP. The carried interest rights, entitlement of the team are not drastically changing. Of course, we allow some room for changes, but especially if the manager wants to sell the management company, that's a change of control. And that should be discussed with the LPs. So in this case, not the advisory board, but the LPs should clear that situation if there's a planned sale of significant shares in the management company to another manager, to a competitor. This happens in practice. So that should be discussed with the LPs in advance. Otherwise, if it happens, that's a change of control, and that will also tie into a cause event, giving rights to the LPs and removing the manager, terminating the fund, etc. And in terms of conflict of interest, we also have very detailed provision around, as I mentioned in the advisory board section, of managing conflicts. So we have a section on what's restricted for this fund, what type of transactions it cannot enter into without the advisory board's approval, such as all the transactions between related parties and related funds. So buying and selling, we want to avoid that without the consent of the AB. And for the bad days, again, I'm talking about investor protection rights because we need those. Otherwise, we're giving all the discretion to the manager, and we really need your cooperation in helping us secure these rights. And the important one there is the cause and no cause removal rights that we have in LPs that are very, very rarely used in practice, but we need to have robust protection provisions around removal. So with cause removal is really bad acts carried out by the management team, the executives and the persons having signature authority, let's say. So that could be cases like breach of law, breach of the LPA side letter, an uncured key person event, which I just described, change of control that wasn't permitted, fraud, gross negligence, criminal conduct, if the manager loses its license, if it's subject to insolvency proceedings, bankruptcy proceedings. So for all these bad events, we call them cause events. And if they occur, then the LPs have a right to decide what to do. So there's a majority, it's at least more than 50% of the LPs generally deciding on this. And they can decide to remove and replace the fund manager with a new manager if this happens. Or they can decide to terminate the fund. And if a cause event happens, we want to suspend the fund. So the fund enters into suspension mode, meaning that no new investments are permitted during this period, including divestments and follow-ons. So we need to get out of that situation immediately, because that's not good for the fund. So the investors have to make a decision on what to do with the cause event. And then there's the other removal option, which is called without cause or no fault. And there, you don't need to have a specific reason or justification, but this is done where things are not going so well, but the investors don't have a robust argument of what's going on. So they can still go ahead and remove and replace the fund manager, but with a higher qualified majorities. Could be 66% or 75%. But in this case, we pay a compensation to the removed manager for their losses, and the carried interest is paid on a vested scheme. Maybe just before that, I think I forgot to mention for the key person event, now we're also seeing something positive, because we are also permitting absences on maternity leave. So if a key person is going on a maternity leave, then of course that will not trigger a key person event. So that's considered as a permitted absence. Yes. And fund economics. So here you've seen in the presentations before, my colleagues talked about the team commitment, what is the standard, etc. So the team commitment will be spelled out in the LPA, and the so-called skin in the game. So for the portion of the team commitment by the GP, they will be treated like LPs. So equal treatment into the profits and losses. And on the management fee, we will also have a section on this in the LPA, and the fund will pay to the GP the specified management fee. It will differ during the investment period and after the investment period, so usually it will be based on the total commitments during the investment period, but post-investment period, it may be based on net invested capital. And then you'll have the EIF cap for the whole term of the fund, together with fee offset mechanisms. If the fund manager has received a success fee from a portfolio company, some advisory fees, etc., those will be set off from the management fees. So one line of income for the GP, for the management of the fund and their investments. And in terms of expenses, so the biggest cost at the outset will be your setup costs, so-called establishment expenses, and you will pay a fortune to your lawyers for that. You will discuss it with us, and we will agree on the ceiling for the setup costs. And then the ongoing costs are more market standard, and the common interest is to keep all those low, obviously. So lastly, on fund economics, I have the slide on the famous waterfall, how the distributions of the fund are allocated between the LPs and the GP. So this is a very standard waterfall. In Europe, we use the whole fund model, whereas in the US, they do more deal-by-deal waterfalls, meaning more frequent distributions to the LPs, whereas in Europe, we tend to see distributions at a later stage towards the end of the life of the fund, where the money starts really flowing from the exits. So you have 4 steps in the LPA. When the capital starts to be returned, the first step is returning the first line of distributions to the LPs, and they need to receive their entire contributions. So after the LPs have received their whole contributions, then we go to the preferred return, the hurdle rate. So all distributions continue being paid to the LPs until the hurdle rate, the preferred return, is reached. So that's usually 8%. There could be multiple-based IRRs and VC funds, but I do private equity, so I don't know those very well. And then on the third line, we have the GP catch-up line item. So all the distributions then start being paid to the GP, and until it catches up to 20% of the profit. So that means the item 2 and 3 as a total will be 20% of item 2. And afterwards, the carried interest and the remaining distributions get split into 2. So 20% of that goes to the GP and 80% of the remaining to the LPs. However, we also are keen on having certain securities for our investments, so the so-called escrow account. Although in a whole fund model, it's less risky that we will have clawback risks and overpaid carry, but it could happen. And what we ask the fund manager is to set aside in the name of the fund an escrow account, and that account cannot be touched until a certain period. And we talk about percentages, how much of the distributed carry will go into the escrow account and just wait there. But I think for first-time teams, it's generally 100% of the carry, so you really wait until the end to get your carried interest, because we need to do the whole fund calculation that actually the preferred return is reached for all the distributions. And also we have clawback mechanisms in the LPA, meaning that besides the escrow, if again the carried interest has been overpaid, then the GP has to return that first, and we have several provisions around this. But vis-a-vis the fund, so we have the GP liable, but of course the GP will have at the back distributed carry to other persons that are not necessarily party to the LPA. So also you will have in your, let's say, background agreements, arrangements with your team on how to handle all those. So you may also have your internal escrow accounts and vesting schemes, etc., to arrange all that risk, because otherwise the GP itself is just signing the LPA and not all the carry recipients. So it's a bit technical on all that stuff. I will conclude, and as Raluca mentioned, please make sure that your lawyers are really instructed to be constructive with us, because we are really dedicating a lot of time to this, and we will not sign a deal until we reach all the protection rights that are ideal for us. And also, please be active in all the conference calls, etc. Don't just delegate to your lawyers the decision making, because we actually need the team to be there to make the decisions and give concessions if necessary. So it's a joint effort throughout this process, and that will get us to signing. So thank you. Questions?
We've got questions coming in if you want to take a seat. And we've got 2 questions from online, thank you. And we've got questions in the audience as well. So first question from somebody anonymous online. Can you share a standard LPA for VC funds with standard clauses which you will request? That way, even if you're not on board with the first closing, we can already address your requests. Not yet.
Do you want to take it?
I can. The short question is no, because we are not providing legal advice to the GPs. That's an important part of their setup of a fund. And also it is linked to the liability that is created in the process. So we are actually encouraging diversity in the market at EIF. We do not want to advise only one law firm that you should work with, or only one standard. There are, however, associations are out there like LPA and others that have over the years produced such standard templates that you can draw inspiration from. But know that we are using, or rather we are coming in contact with very different legal structures and very different documentation. And we are open to negotiate whatever you choose, choose wisely, however, as I said earlier, but do not expect EIF to prepare the documents for you, because we are not set to do that, and we also have our own reasons to want to have a limited involvement. But we will for sure engage in extensive negotiations on the documents that you produce, and you will be provided with a term sheet normally by our front office colleagues during the early phases of your interactions that will already be quite comprehensive and contain the main terms that we will need addressed. So you can always start from that and liaise with your lawyers to build upon a proper first version of the LPA.
I know we have questions in the room. If you can keep your hands up, then we can get a microphone to you. We have one, just before I go to you, one other quick question, which is an interesting question online. How long do the legal negotiations with the EIF typically take?
Very long sometimes, but setting aside the process of the first screening, second screening, due diligence, etc. So after it comes to us, that I think in average it will take around 3 months. If it's a straightforward negotiation, we've had longer ones and shorter ones as well.
Thank you.
From Morphosis Capital. I have a question regarding the setup of the funds. In the past, there was lots of funds settled, fund managers registered in Luxembourg and Dutch jurisdictions. I see, at least in my geography, many funds are pushed to be localized by the local authorities. Do you see this trend in other countries? I'm willing to know what happens in Germany, in France, in other European countries, and what percentage of the funds are still, the funds you are negotiating with are still Luxembourg and Dutch-based? Thanks.
I can perhaps take that one. What happens in Germany is a very good question, but probably the topic for another discussion altogether. I think for the big private equity and VC markets in Europe, and this includes Germany, France, Italy, you usually see indeed local structures. There are some who choose particularly Luxembourg for tax reasons or other considerations. But it's true that we come across more and more Eastern European, Southern based funds. And that probably ties to the previous questions. How long does it take us then to negotiate those funds? Longer, honestly, than with the more established jurisdictions, because often the local legislation is not really drafted in a way that accommodates the specificities of this industry. But we are dedicated at EIF to find workable solutions, and with the right lawyers on the GP side also we have managed to close funds in all the jurisdictions that make up the European Union today. So it's not mission impossible, but again you need to have, I think, a right analysis when you choose where to base your fund, because doing a local one in a jurisdiction where you don't have a set up industry is probably going to require more creativity for the lawyers at least.
We've got 1, 2, 3 questions this side, so we start with you.
Andrea Constantinescu from Planet First Partners. A question: what is the success rate for first-time funds? And the second, what are the more problematic clauses that ultimately lead to failure to get to signing from a legal perspective? Thank you.
Success rate meaning? I guess that's more a question for our front office colleagues, as we don't have a lot of visibility in legal on the very early stages of the screening phase where most of the rejections take place. But it is very competitive. I think it's only a small percentage that make it to signature, because we are seeing thousands probably of applications. Cindy is volunteering an answer.
Thank you. So yeah, as Raluca mentioned, the rejection you will experience that the earlier you are in the process, the most likely the funds will be rejected. When we have approval and we enter legal negotiation, it's pretty rare that at that time we don't find agreement with the counterpart to sign the subscription form and to enter into the fund. So it is really more, before approval that we would have during our analysis that we will have reasons to reject.
And it's an interesting question, if I may, Gizem. It's an interesting question. Why do we break negotiations and don't make into signature? And the answer is going to be even more interesting, because you'd expect, economic terms to be at the origin of most failed deals. But actually with EIF, it's often the unexpected policy-related requirement, things like visibility wording that needs to be included in the contracts downstream with portfolio company, some audit rights that we need to guarantee for the EU institution that are responsible to check that the EU budget is spent according to the law. So these things that are not market standard for most VC and private equity funds are going to unfortunately cost the signature in cases where the manager cannot or does not want to accommodate, because as I was mentioning during the presentation, EIF has to guarantee that those requirements are complied with if they are part of the mandate that is used to fund the underlying investment.
Question from this gentleman here, and then get a microphone to the lady here just in the second row. If you put your hand up, he knows where to come with the microphone.
We can hear you.
Okay, good. So my question is related to the time when the EIF comes in. So if there has been a first closing, so a signed LPA, and then the EIF comes in for the second closing, and how that then works. So is there a procedure? Because it's probably a bit painful to open up all agreements from the first closing, but as I understood, it's probably required. So how you cope with these kind of situations?
So this could happen as well. We could come at a later closing if that's agreed and it's viable for our business needs. But we have some mandates that require us to go into the first closing. So then we cannot use that mandate. But if the mandate allows, if the strategy allows, then what we would do is you would enter into a negotiation with us. So we would agree on an amended LPA. And then you would have to go back to your existing LPs and take their permission for those changes. And they always confirm, because the changes that we make are 99% good for them. Although there will be some policy provisions, etc., that could also make the life of the fund manager difficult. But they will want the EIF in the fund, so the LPs will approve.
If I may just add from experience, because we are running our 9th fund generation and working with the EIF since 10 years, what you can do in such cases is flagging out the major issues very early with the EIF, bake them in your first closing LPA so you don't open up major points then when onboarding the EIF. Has worked very well with you guys. Thanks.
Great point.
Lady here.
Thank you. So I'm curious, we heard how it is for fund managers, it's pretty hard. How it is for other LPs, how do they see your process and your requirements? And do you also have requirements for other LPs that are coming in the fund?
As far as we are aware, I don't think they have big concerns. I think usually the presence of EIF in the investor base is seen as a positive signal by the rest of the players in the market. And like I said during the presentation, they probably count on us to do the negotiation thoroughly, and then they're more happy to sign off on the terms of the funds as negotiated by us. We do have cases, especially with institutional investors, where there will be some coordination behind the scenes. Some of the NPIs that are also supporting this market are our shareholders, so they might reach out, we might reach out to understand the background of the team and to reach a consensus on certain terms that need to be coordinated. But for the most part, I think the value added brought by EIF is recognized in the market. And it doesn't come just from our deeper pockets than average, but also from the thorough negotiations that improve usually the fund documentation.
And sometimes the terms may conflict. The EBRD term may conflict with the EIF, so we kind of come together and then find a solution with them.
We have another question online. I don't know if we have any final question from the room. Yeah, we have one over on that's all on this side. There's a question there. If you keep your hand up, you'll know where to walk. Meanwhile, online, what is the legal team of the EIF doing to support increased gender diversity in the funds supported by EIF and the industry more generally?
Oh, wow, good question, and very on point. Well, obviously, we work closely with mandate management, front office, and all the other services to transpose all the terms and conditions that are emerging in this sphere of gender balance into the documentation that EIF is ultimately signing. But I guess the question should also be answered from the perspective of what are all of us players in this ecosystem doing internally to meet the challenge that gender diversity is posing. And if I take myself as an example, I am a female lawyer, relatively young, expecting, leading a team of lawyers at EIF. So, on the first look, it's actually the poster girl, right, of gender diversity in the institution. But of course, we wouldn't need this type of events if gender balance would be such a straightforward thing in reality. So I have to be transparent and say that I work for a man boss who also reports to a man boss above him. And while we do see that there is a wind of change also at the EIF and the EIB group more generally, we still are on this journey, and we see the destination in sight, but we have yet to take steps to reach it. So we try, from the bottom up to make as much as possible a difference, and we have a diverse team at EIF. We also interact closely with the law firms that are active in the market, and every time we renew our panel, we question them on their gender diversity policies and what they're doing to improve in that respect. And I have to say that I have seen over the years, indeed, more and more focus on this and a better representation. So we are in the early days, but promising days of more diversity also for the support services and support industry around the main funds business that we are here to discuss today.
Thank you and congratulations. We have a question here.
Congratulations. Margaret from Polish Development Fund of Funds. I have a question regarding the removal for costs. How many of those you had for the last 30 years? Can you share it with us?
Pretty much none. But we've had bad cases, and we have settled bad cases, and as far as I'm aware, none. Uli, are you aware of?
We have some on the VC side, but
but there's our processes. We have triggered the processes. Oh, we did have one replacement, though. Yeah, it was.
He's saying two.
2 in the last 25 years.
2 in the last. Perfect.
But if I may use this question to also make a clarification, Gizem has given a very good summary of the for cause and without cause removal, but I want to take the opportunity to clarify that there isn't in practice ever a without cause removal. It would not make economic sense. And I think for any LP that would trigger something like that, it would be the end of their presence in the market. So often we are talking about without cause removals, where in reality there is a significant breach in the trust between LPs and manager, and some misconduct that is either hard to prove or it takes too long to get into. So we are using this option B, let's say, to deal with the cases where the managers are not performing, but not in the sense of returning, I don't know what percentage of hurdle, but really mismanaging the funds they're entrusted with and the relationship with the investor. So I think that the question is probably hard to answer, because in reality, it should also capture the non-cause removals.
Do we have any fabulously burning questions in the room? No, in which case I think it's time for lunch. And we will start back here. First of all, thank you to our fantastic speakers.
Thank you also for the question.